Good day, Crime Talk aficionados. Is there going to be no alibi for Bryan Kohberger? Karen Reed's hearing turns into a fiasco, at least in my opinion. Learn to let it go, or you could go to prison. A man who has had 9 execution dates and 3 last meals gets a new trial ordered by the United States Supreme Court. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, go check us out on any of your favorite podcasting apps as well. So we did our Tuesday night live program last night. I hope you were all able to watch that and enjoy it. It was a good discussion. We talked a lot about the Karen Reed case as well as the Bryan Kohberger matter. And then we had a very vibrant conversation about the Karen Reed case for our Patreon members as well. So if you're a Patreon and you didn't join in, go check out that video as well. You know, you've got the secret link. All right. Before we get started on the docket, you know, CrimeTalkSearch.com. I'm telling you, we use this in our law office every day. When we were down in Arizona looking for witnesses, trying to find out some good addresses for a couple of people that have kind of fallen off the earth, so to speak, guess what? We found them based upon information from CrimeTalkSearch.com. It's amazing the amount of public information that is out there in regards to phone numbers, email addresses, social media presence, whether people own property, where they've lived, where they are living now. It is amazing. So if you want to get a background search with people's criminal histories, information about whether they're married or divorced, go to CrimeTalkSearch.com. That report is literally generated while you wait. And the beautiful thing is it is updated. So if the information changes, they're going to send you a notice that it will be updated. Go to CrimeTalkSearch.com. You're going to be happy that you did. All right, let's go ahead and open the record today for February 26th, 2025. Can you believe it's already February? End of February. All right, first on the docket, Bryan Kohberger. Is he not going to be able to present his alibi witness? Well, the Latah County prosecutor, Bill Thompson, has asked the judge to limit any alibi evidence during Bryan Kohberger's trial in a motion in limine that was filed and released yesterday afternoon. He also asks Judge Hippler to limit evidence about psychiatric evaluations Kohberger might have undergone, as well as arguments about the alternate perpetrators at the crime scene. Now, attorneys for both sides are attempting to kind of lay the groundwork. That's the whole purpose of motions in limine. As you get closer to trial, you figure out what's coming in, what's not, what shouldn't come in under the rules because it's too prejudicial, or frankly, just simply not relevant under 401 of the rules of evidence. Now, the trial is scheduled to take 3 months, and it is set to begin on August 11th. Now, Kohberger's defense team had filed a notice of alibi months and months ago that said that Mr. Kohberger was out driving in the early morning hours of November 13th, 2022, as he often did to hike and run and or see the moon and the stars. The defense has also said that an expert in cell phone tracking would partially back up those claims by testifying about where Kohberger's mobile device was during the hours of relevance. However, like I said, the prosecutor, Bill Thompson, stated in his motion that the defense team hasn't provided enough specific details about exactly where Kohberger's claims to have been, and that the defense, have failed to meet their disclosure deadlines set by the court. And the prosecution states it would be unrealistic at this date to expect the state to effectively investigate and respond to any new or additional alibi disclosures. And they further went on and said that any alibi evidence should be barred unless it comes from Mr. Kohberger himself. Thompson also asked the judge to limit arguments about possible alternate perpetrators or alternate suspects unless the judge decides that the evidence is somehow relevant when they get to court. In this case, during the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement, and none of those tips were substantiated except for the information regarding the defendant, Mr. Kohberger. He also asked that some testimony of the neuropsychological and psychiatric evaluations of Mr. Kohberger not be allowed to be introduced into evidence under the rules of evidence and state law there in Idaho. Now, the defense attorney, Ms. Taylor, asked the court to have permission to file a lengthy court document that will include motions on a variety of things, including improperly disclosed expert testimony, reference to touch and contact DNA, and witness identification by, quote, bushy eyebrows. The judge approved Ms. Taylor's request to file this lengthy document, but it has not yet made it to the public. So, like we like to do in all of these cases that we talk about, let's go directly to the documents. All right. And I think the state's motion in limine regarding the alibi is perhaps the most interesting. Let's go quickly chronologically through this. It says, by way of background, the state refers the court to the following. The state's May 2023 request for discovery disclosure alibi demand. The state's July 22nd, 2023 motion to compel notice of defense of alibi or alternatively to bar certain evidence. The defendant's August 2, 2023 objection to the state's motion to compel the defendant's alibi. And then they attach a transcript, which we'll go over in just a second. And at that partial transcript back in August of 2023, the court hearing relating to alibi, where the Judge John Judge at the time, observed that the defendant's proffered so-called alibi was not really an alibi, and that he'll address that issue regarding the alibi disclosure at a subsequent scheduling hearing. And then in August of 2023, the scheduling order addressed the deadline for the defense to comply with the statutory obligations. That was August 2023 when the defendant waived speedy trial. Then on December 21st, 2023, a motion for a scheduling order, which is the second full paragraph of the page 3, refers to the issue of alibi. And the defendant's April 17th, 2024 notice of defendant's supplemental response to state of alibi, and the state's April 26th response to notice of defendant's supplement regarding alibi. Anyway, the judge's scheduling order, which is subsequent to April 17th, alibi disclosures, and which make no further reference to alibi. The prosecutor notes it has now been approximately 20 months since the state's first made its request for discovery disclosure in regards to the alibi. And then on May 23rd, 2023, as of the court file reflects, the defendant has failed to comply with the requirement under Idaho Code Section 19-519, as well as the Idaho Criminal Rules 12.1. The defendant has yet to specify the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish the alibi, as directed by the February 23rd, 2024 order setting deadlines and hearings, as discussed in the state's April 26, 2024 response to the notice of the defendant's supplemental response to the state's alibi request. Anyway, it goes on, even where the defendant is attempting to comply at this state in time, the state is irrevocably prejudiced. It has now been over 2 years since the homicide occurred, and it would be unrealistic at this date to expect the state to effectively investigate and respond to any new or additional alibi-related disclosures. This is precisely the situation that caused concern for the Idaho courts on appeal in State v. Juarez, as well as concerns in the United States Supreme Court case of Williams v. Florida, where the court noted that the ease with which an alibi can be fabricated and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. The Supreme Court held the adversary system of trial is hardly an end in and of itself, not yet a poker game in which players enjoy an absolute right always to conceal their cards until played. We find ample room in the system, at least as far as due process is concerned, which is designed to enhance the search for the truth in the criminal trial by ensuring both the defendant and the state ample opportunity to investigate certain facts crucial to the determination of guilt or innocence. For these reasons, the court should issue an order prohibiting the defendant from presenting any evidence where the direct or cross-examination in support of the claimed alibi. There was a discussion a hearing on the 18th day of August, 2023, where Judge basically says what you've provided thus far driving around is not really an alibi, because normally an alibi is you have to notify the prosecution whom is going to come and testify and say, this is where this person was. Well, as far as we know, Kohberger has no person to say that he was with at that particular time. A cell phone expert is not really an alibi, so to speak, because he wasn't with the defendant. He's not going to be called to testify about that. That evidence could come in through the expert witnesses when they're going to testify, even by the prosecution, as to where Mr. Kohberger's phone was at the time of the alleged offense and when it was on and off. Fair enough. So I see what the prosecution is trying to do. They're saying, hey, they haven't produced any alibi. You shouldn't be allowed to do this. And they're trying to force Mr. Kohberger to take the stand. I don't think that this is going to work for the prosecution. I think the judge is going to allow in the evidence related to the cell phone data because the prosecution is going to bring in the cell phone data to say that his phone was off during certain periods of time. Coincidentally, the prosecution says that it was off, the phone was off when the murders occurred. And he just happened to be driving back, in enough time after the murders to go back to his residence. The defense can get that on cross-examination or potentially through their own expert if they intend to call one. I think that's fair game. But there is no real alibi where, unless Mr. Kohberger gets up, and he has an absolute right to get up and testify and say, I wasn't there, here's where I was. But you would think if you had a solid alibi that you would want to present that immediately so that you could be freed from custody. Let me tell you, never had an alibi defense work. Oftentimes when the client will tell you, I was with this particular person. Okay, well, I need to go talk with them because guess what? I'm going to have to endorse them and they're going to have to say where they are, what they were doing with you at the time. And guess what? If that doesn't check out, if your story crumbles, they're probably going to get charged with attempting to influence a public official if they testify that, or possibly even perjury. So I'm just telling you from experience, never had an alibi go to court. Now, I have had alibis where it was locked solid, and guess what? The charges were dismissed, and we didn't wait until trial to present that to the prosecution. So I think that's interesting, and the defense needs to come up with something. Now, the other motion that was filed, and the defense will certainly file their response, and that relates to the alternative perpetrator evidence. As we talked about last night, we went through the transcript of the secret hearing. Obviously, there was some DNA found on one of the staircases going up, as well as a glove outside that apparently the prosecution did not pursue in any way. Doesn't mean that Mr. Kohberger, because his DNA is there, and the judge noted this, that doesn't mean if there was DNA from other people, and let's say they participated in it, how is that really exculpatory for your client, since your client's DNA was somehow on the sheath, somewhere on the button? Makes sense, right? So once again, quick motion. The prosecuting respectfully moves this court in limine for an order prohibiting the defendant from offering alternative perpetrator evidence or argument without first satisfying the court that any such evidence is relevant and admissible pursuant to Idaho Rules of Evidence 401, 402, and 403. Obviously, 401 has to be relevant. Same thing under 402. 403, the probative value must not outweigh its prejudicial effect. In support of the motion, the state refers the court to a case called State v. Meister, where the Idaho Supreme Court addressed the standard of assessing the admissibility of alternative perpetrator evidence. And in Meister, the Supreme Court held that the rules of evidence implicitly overruled a previous case under that analysis and noted that the trial court first must consider and determine whether the proffered evidence is relevant under 401. The second step is to determine whether the probative value of the proffered evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. That's Rule 403. noting the Larson court was concerned that the defendant will attempt to admit evidence where the sole purpose is to infer that an individual other than the accused committed the crime. The Supreme Court said, quote, if the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable, then it is within the trial court's discretion to find the evidence inadmissible. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitation provisions of the Rules of Evidence 403. Anyway, the motion says the state submits that any attempt by the defendant to offer or argue an alternative perpetrator theory without evidence, specifically connecting persons other than the defendant to the homicide, will do nothing more than mislead and confuse the jury and will result in undue waste of time. We have these two unidentified DNA samples. Basically, we know from the secret hearing that we discussed last night in greater detail with the transcript that really nobody really did much of anything with that particular evidence. I think where it is relevant is into the collection and to the investigation as a whole. You collected this evidence, you tested it, it didn't match Mr. Kohberger, you don't know who it came out to, not once, but twice. And you found it on a glove outside as well as inside, correct? Yes, I think that goes to the collection of evidence. But defense will more than likely be limited and will not be able to argue that the real killers left their DNA there and somehow Mr. Kohberger's was planted. So I think that's where the issue is and what the court will rule. And then, of course, there's a motion in limine regarding neuropsychological and psychiatric evidence. So apparently there's been some evidence submitted in exchange and discovery as it relates to expert witnesses. Obviously, a neuropsychological examination took place and some sort of psychiatric evidence. Well, that would be for a not guilty by reason of insanity. So the prosecution is appropriately moving for a motion in limine saying this is of no relevance whatsoever. It doesn't go to negate any particular element of the crime, i.e. knowingly. So therefore, it is irrelevant. Now, it may be useful for mitigation if Mr. Kohberger is convicted after the prosecution proves their case beyond a reasonable doubt, unanimously to 12 jurors, but it is not relevant as it relates to the case in chief, and it doesn't go to negate an element. The defense would have had to endorse some type of not guilty by reason of insanity defense for that to be relevant. And then, of course, Miss Taylor filed a motion to exceed the page limit, and they want to get into their motion in limine, and it's going to be regarding improperly disclosed expert testimony regarding Rylene Nolan and reference to touch and contact DNA, motion in limine regarding witness identification by bushy eyebrows, and motion in limine regarding conditions as aggravators. So the improperly disclosed evidence, not really sure what they're talking about as it relates to the DNA. Reference to touch and contact DNA, that should be completely ripe for presentation to the jury and subject to cross-examination. How does the DNA get there? What are the possible ways it could have gotten there? Probably didn't float 40 miles from Mr. Kohberger's house to wind up on the K-bar sheath. But obviously the defense wants to limit speculation as it relates to that. Witness identification by somebody in the house, obviously the victims. We talked about that last night in the transcript as well. But the bushy eyebrows, more than likely what they are going to ask for is that the witness in the house, one of the roommates, not be allowed to make an in-court identification of Mr. Kohberger as it relates to could that be the man with the bushy eyebrows. Since there was no identification, as far as we know, from that witness, it would be improper to do for the first time an in-court identification of that witness. And then the conditions of the aggravator, that's more of a question for sentencing, but There you have it, ladies and gentlemen. A busy day in the Bryan Kohberger matter. And go check out the video last night, our live, because we went through the secret transcript and I gave you the high points. Interesting information. I'm telling you, that's where the meat of this case is, the motions practice, the motions hearings. And it's such a shame that Idaho has these ridiculous rules where everything is sealed. I'll just leave it at that. Next on the docket, Karen Reed had another hearing. Nothing got accomplished. And boy, did it kind of spiral out of control. So the judge in the Karen Reed case abruptly ended a motions hearing last week, February 18th, telling the attorneys that she had just been provided information that caused her grave concern. Not just concern, but grave concern. And anyway, so she had a hearing that was yesterday, and we brought it to you live. If you want to check out that hearing, you can. I'm telling you, though, the defense droned on and on and on for about 4 hours. The prosecution did their statement in about 30 to 45 minutes. And I think what you can glean from the defense was, thou protest too much. Okay. Anyway, the judge explained her reasoning, saying that she was alarmed to hear that a previously undisclosed relationship between Reed's attorney and expert witnesses in her first trial that wasn't properly disclosed. So at the first trial, Reed's defense team had 2 accident reconstruction experts initially hired by federal investigators, and they testified on Miss Reed's behalf. Now, midway through the trial, Reed's defense, led by Alan Jackson and David Yannetti, told the judge that they had no contact with experts before their testimony. But on February 18th, the special prosecutor, Hank Brennan, revealed documents that showed several messages between Jackson and the experts about what they would and would not testify to, as well as an invoice for $23,000, which was ultimately paid by the defense. Well, Robert Alessi, he was another attorney brought in to basically handle this issue. And I said, if you go back and look at my video last week when all this went down, I said, oh, yeah, Jackson better get himself an attorney. He should not be doing any talking. All right. So anyway, this Robert Alessi guy gets up and he drones on. And he got up there and represented the team as a whole in addressing the issues at the hearing yesterday. Now, according to Alessi's account, the sole contact with the expert was through Jackson and was limited to simply coordinating testimony. They were talking about what should and shouldn't be asked. And anyway, Mr. Alessi said, this is one of the most unusual situations I've seen in my practice of law. You have these experts, you have great exculpatory information, but there's significant restraints in how you can use the information. And that issue with the expert witnesses in this case, Alessi explained, was that they had been hired by the United States Attorney's Office because the feds were doing their own investigation, but they had contributed reports that were exculpatory to the defense. Alessi emphasized that regardless of any communication between Reed's team and the witnesses, the reports were written well before the trial and no information within them was ever changed. Now, when it comes to explaining the $23,000 invoice that was paid, Mr. Alessi said the defense team was a bit shocked that they had actually received a bill. It came out of the blue. It gets sent to Mr. Jackson's office apparently in July. Now, he said he couldn't go into attorney-client communications, but there was one person that was more shocked than most about the invoice coming in and the amount. Now, Mr. Alessi emphasized that the invoice was dated July 12th, which was 1 month after Reed's first trial ended in a mistrial. Now, Alessi did confirm that Reed paid the invoice after Jackson consulted with the United States Attorney's Office to confirm that paying the experts was legal and appropriate. That was news to Mr. Brennan, who said it wasn't until Your Honor asked today that we even knew that the defense paid this bill. Anyway, after Mr. Alessi did his presentation, which, like I said, goes on for 4 hours, the judge addressed Mr. Yannetti and Jackson basically personally, and attorney Elizabeth Little as well, in turn to ask whether they disputed. And they each indicated that Alessi's versions of fact was correct. Now, Mr. Brennan, the special prosecutor, fired back at Alessi's claim that the defense has repeatedly violated the court's rules, calling minor violations a raindrop in a hurricane, and emphasized that his intention is not to preclude the experts from testifying, but rather to get the discovery evidence to which he is legally entitled. So Brennan characterized the defense relationship with the United States Attorney's Office as murky and said there were enormous gaps in time between emails that suggest there is an unclear history of interaction between the defense and those expert witnesses. Well, the judge, as normal, adjourned at 4 p.m. and said that the parties would reconvene the hearing next Tuesday on March 4th, and will decide where they go from there if necessary. A couple of things I think came through from this. One was there was definitely contact by the defense. The defense's argument was, well, there's contact, but it doesn't really matter because they were going to testify to the same thing anyway. The point is they made material misrepresentations to the court, and at some point, Mr. Jackson is asked by the court, did you pay them for their testimony? This was at a sidebar at the hearing on the 18th. And apparently Mr. Jackson said, I did not pay them for their testimony. I paid them for their time. Well, I think you have a duty of candor to the court. If they were some third-party witness that was testifying for the good of the cause, so to speak, and to make sure the truth got out, I wouldn't be paying a $24,000 bill. I assure you of that. Unless, of course, they thought they were going to get paid. Well, the drama continues in the Karen Read case, as it always does. And like I said last night, we've got the Karen Read camp that obviously thinks that she can do no wrong, and then the camp that says Karen Read is so guilty. How could anybody believe that she didn't hit her former boyfriend, Mr. O'Keefe? Anyway, the bottom line is I get complaints from both sides, so I guess I must be calling it fairly. All right. I have said in the first trial that I watched that I would have found her not guilty in the first trial. But I also have said that I think the wheels are starting to come off on the Karen Read defense team's case. And I think because the defense normally doesn't do better the second time around, that, like I said, the wheels are starting to come off. So we'll see. Let me have it. Let me have it. Bring it on, the Karen Read camps. Guilty camp, totally innocent camp. I'm sure you're upset with something that I said, so bring it on. Next on the docket, let it go or go to prison. So Georgianne Garner died Saturday after a driver pulled up alongside her vehicle and shot her at point blank range down in Panama City, Florida. Now, her daughter, Marlee Lewis, was in the back seat at the time and was shot in the chest. Now, Georgianne had been celebrating her birthday at a Mardi Gras parade in Panama City Beach just minutes before the attack. Now, the pair left the parade about 4 p.m. and were driving to a local restaurant for dinner when they were involved in a minor traffic incident with a guy by the name of Jubal Simmons. Ivy Bella Encino, an occupant from Miss Garner's vehicle, went back to the Encino vehicle and struck Miss Encino, and that was the conclusion of it. It wasn't a big drawn-out brawl or anything like that, according to the police department. But then there's video shot by a witness that shows a gray Dodge pickup truck, reportedly driven by Encino, pull alongside the red GMC Terrain with both Georgianne and her daughter and another passenger inside. Suddenly, a passenger in the pickup pulls out what appears to be a gun and sounds like at least 11 gunshots, and then the truck speeds away. Obviously, the police were called. They arrived on the scene shortly thereafter, and what the officers discovered in a nearby parking lot was gunshots, and they saw this gray Ram speeding away, heading north. Simmons fired 11 rounds, hitting both Garner and Lewis in the chest and also striking an uninvolved car. The vehicle was eventually stopped at a nearby Holiday Inn where they contacted the driver. Encino rammed into the police cars before she was detained. Not good. Simmons, the suspected gunman, who was a passenger in the Dodge at the time, ran away from the scene, but was ultimately arrested. Now, both Georgianne and Marlee were rushed to the hospital where mom died. Garner has never met Mr. Encino or Simmons, according to the police. Marley, the daughter, suffered a bullet to the chest and almost lost her life. She apparently is in ICU, but they believe that she will, in fact, survive. Evidence indicates that the incident stemmed from this Encino and Simmons getting upset over this traffic and verbally assaulting the occupants of Miss Garner's vehicle. Then the obviously escalated to a brief physical altercation between Lewis and Encino before all parties separated and got back into their cars. Mr. Simmons faces 9 charges, including murder, 3 counts of attempted murder, tampering with evidence, and resisting arrest. He is being held without bond. Miss Encino, the girlfriend, was charged with being an accessory to murder, aggravated battery on a law enforcement officer, and driving while her license was suspended. Her bond, $800,000. Let it go, ladies and gentlemen. A little minor car accident. Listen, you got insurance. It's stuff. Is it really worth going to prison for the rest of your life? Somehow, I would say no. There's some things that you say worth it, but not that. Next on the docket, a man who has had 9 execution dates set, had 3 last meals, gets a final reprieve from the United States Supreme Court, and gets a new trial. We briefly mentioned this last night in our live, but it's worth going over in a little greater detail. So the United States Supreme Court on Tuesday ruled that Richard Glossip, who is on death row in Oklahoma for his role in the 1997 murder of motel owner Barry Van Treese, should get a new trial. Now, in a decision by Justice Sonia Sotomayor, the majority agreed that the prosecution violated their obligations to correct false testimony and that the jury might not have sentenced him to death if the testimony, which was false, would have been corrected since the prosecutor knew that it was false. Now, prosecutors have never contended that Glossip himself killed Van Treese, who owned the Oklahoma City motel where he worked. Justin Sneed, who worked as a handyman at the motel, confessed to murdering Van Treese, but testified that Glossip paid him to do so. In exchange for his testimony, Sneed was spared the death penalty. Now, Glossip has maintained that he had no part in the murder. And in 2023, Glossip returned to state court in another effort to set aside his conviction and sentence. He contended that the state had recently given him, for the first time, files indicating that prosecutors knew but failed to tell either Glossip or his lawyers that Sneed had been prescribed lithium for a bipolar disorder after his arrest and had lied about it. Prosecutors allowed Sneed to testify falsely that he had never been treated by a psychiatrist and that he had been accidentally prescribed the drug for a cold. Well, after 2 different independent reports questioned the validity of Glossip's conviction and death sentence, the state attorney general, a Republican, Genter Drummond, joined Glossip's request for the Oklahoma Court of Criminal Appeals, the state's highest court for criminal cases, to set aside the conviction as well as his plea for clemency from the state's Pardon and Parole Board. Both requests were unsuccessful, but the Supreme Court agreed to put Glossip's execution on hold and take up his case. In a 29-page opinion, the justices reversed the state's court ruling and set Glossip's case back for a new trial. Now, under the Supreme Court's 1959 ruling in Nape v. Illinois, Sotomayor explained, prosecutors violate the Constitution when they knowingly obtain a conviction using false evidence, either by soliciting false testimony or allowing false testimony to stand without correcting it. And when that happens, she continued, the defendant is entitled to a new trial if there is a reasonable chance that the false testimony could have affected the jury's decision. Now, Sotomayor reasoned in this case, Sneed's testimony was false, but prosecutors knowingly failed to correct it. Sneed was diagnosed with bipolar disorder and received lithium while at the local sheriff's department, and a psychiatrist testified both that he was the only healthcare provider who could have prescribed the lithium and that the lithium is only used to treat psychiatric conditions. The evidence likewise establishes, she added, that the prosecutors knew Sneed's statements were false as he testified under oath to those statements. And if prosecutors had corrected Sneed's testimony, the Supreme Court wrote, there is reason to believe it would have made a difference because Sneed's testimony was the only direct evidence of Glossip's guilt of capital murder. The court observed the jury could only convict him if it found Sneed credible, which it would have been less likely to do if the prosecutors had corrected Snead's false testimony. As a result, the Supreme Court said Mr. Glossip is entitled to a new trial. Now, the Oklahoma Court of Criminal Appeals, Sotomayor continued, based its conclusion that Glossip was not entitled to a new trial on a mistaken interpretation of NAPE, previous case from the Supreme Court back in 1959. Although the state court believed that prosecutors had not violated NAPE because Glossip's lawyers knew or should have known that Snead was taking lithium, Sotomayor emphasized Snead's false testimony concerned the reason for his lithium prescription, which Glossip's lawyers did not know, rather than the mere fact that he had taken it. Similarly, although the state court held that Snead's testimony was not clearly false because Snead's may have been in denial about his mental health issues, the Supreme Court added Snead's beliefs are beyond the point. What matters is the testimony was false and the prosecutors knowingly let it stand nonetheless. The Supreme Court brushed aside an issue that the court had instructed both sides, as well as the friends of the court, to address, and that was whether the Supreme Court had the power to review the state court's decision at all. Christopher Michael, the Washington lawyer and a former clerk to Chief Judge John Roberts, appointed by the justices, had argued that it did not because the state court's holding that Glossip's claims were barred under the state law governing post-conviction procedure was the kind of pure state law ground that the United States Supreme Court lacks jurisdiction to even consider the case. But the state court applied the state law, and Sotomayor noted only after it rejected Drummond's concession that the prosecutor's failure to correct Snead's false testimony violated NAPE, and because of that conclusion, rested exclusively on federal law. Now, Sotomayor stated in her opinion, concluded its decision to apply the state's post-conviction law did as well, and therefore the court had the power to review the state court's ruling. Now, Justice Amy Coney Barrett wrote an opinion concurring in part and dissenting in part, and Barrett agreed with the majority that the court had the power to review Glossip's case, but she believed that the Supreme Court went too far when it ordered the state court to set aside Glossip's conviction and require a new trial. She agreed with the majority that the state had misapplied NAPE, and she would have simply sent the case back to allow it to make findings about the significance of some of the evidence on which the majority relied to conclude that the prosecution had failed to correct the false testimony by Mr. Snead. Particular to notes taken by one of the prosecutors during an interview with Snead, she suggested that the notes are hardly clear and there are competing explanations of what they mean. When the record in a case can be interpreted in several different ways, she argued the Supreme Court should not be in the business of choosing between those particular interpretations. Justice Clarence Thomas wrote a dissenting opinion joined by Justice Samuel Alito and in part by Barrett. In his view, the Supreme Court lacks the power to override the denials of relief by the Oklahoma Court of Criminal Appeals and that the state pardon and parole board. Instead, Thomas lamented, the Supreme Court stretches the law at every turn in rule of Glossip's failure. And Tuesday ruling, he concluded, distorts our jurisdiction, imagines a constitutional violation where none occurred, and abandons basic principles governing the disposition of state court appeals. Justice Neil Gorsuch did not participate in this case because he was involved in earlier interactions of the proceedings while a judge at the 10th Circuit, which includes Oklahoma. So there you go. Prosecutors lie. They know lies are being admitted on the stand. They have a duty to correct them. Otherwise, do-over 30-some years later. Next on the docket, this day in legal history. February 25th, 1869. 15th Amendment submitted to the United States. That's all right. The Congress passed the 15th Amendment and submitted it to the states for ratification. This amendment sought to prohibit the denial of voting rights on account of race, color, or previous condition of servitude, obviously aiming to enfranchise African American men who had previously been slaves. And on this date in 1964, the Civil Rights Act debated in the Senate. The United States Senate received the House-passed Civil Rights Act for debate. Obviously, it was legislation aimed to end segregation and discrimination based upon race, color, religion, sex, or national origin, leading to obviously significant legal and social reforms. Obviously, it was the Southern Democrats that led a 15-day filibuster, but ultimately it was passed in the Senate and became law. And on this date in 1965, there was an arrest in the Malcolm X assassination. That's right, Norman Butler was arrested in connection with the assassination of civil rights leader Malcolm X. And also on this date in 1924, Adolf Hitler and several others were put on trial for treason in Munich in connection with their attempted coup, known as the Beer Hall Putsch, which obviously he was found guilty of and went to prison and then got out. We all know how that turned out. Not so good for anybody, to say the least. And finally, our dumb criminal of the day. I am convinced that dollar store workers are in just as much danger as fast food workers, ladies and gentlemen. Seems to have a trend of dollar stores and food violence at fast food restaurants. Anyway, a North Carolina woman is behind bars after assaulting a Family Dollar worker who tried to stop her from escaping the store with a shopping cart packed with toilet paper. Lakina Stanley was arrested for attacking the store employee over a $6 pack of toilet paper. Now, when Miss Stanley sought to shoplift from the Family Dollar, a worker there, Deja Pierce, attempts to stop the toilet paper theft. Pierce told police that she tried to lock and block the door when the female attempted to leave with the packs of toilet paper. After Stanley pulled Miss Pierce's hair in an attempt to move, apparently the two got in a fight. Needless to say, police found Miss Stanley circulating in the area near the Family Dollar store and arrested her for assault and attempted larceny. She's been charged with third-degree misdemeanors for allegedly damaging Miss Pierce's iPhone during the struggle. Miss Stanley was locked up without a bond, was expected to make an initial appearance later today in court to be bonded out. Well, here's my theory. Miss Stanley, you are a dumb criminal of the day because it shouldn't just be shoplifting, right? If I go into someone's house with the intent to steal something therein, it's burglary. It's not just little petty theft. It's not shoplifting, right? It's a burglary. So when you go into a store and you commit a theft, you're going in the dwelling, the business of another, with the intent to commit a crime in. That should be burglary. This could also be aggravated robbery, at least a robbery, a strong arm robbery from the store as well. Anyway, Miss Stanley, you're lucky you got popped with just a couple of misdemeanors because, frankly, I think it's felony conduct. I get it. You got to have toilet paper, but you got to do something. You can't steal it. You can't take other people's things just because you want it. So, Miss Stanley, you are a dumb criminal of the day. Congratulations. All right, that's all we have for you today, ladies and gentlemen. Hope you enjoyed the show. Join us tomorrow. And remember, the Constitution matters.